following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we break down the rudiments of the criminal justice system within Sri Lanka. The legislature established to protect citizens and instill a sense of law and order for basic crimes have come under scrutiny in certain aspects for being either too lenient or too strong. How has the law against crime and its execution procedure changed over time? Where are the vacuums that have been exploited by criminal entities? What are the key areas of reforms that the criminal justice system needs to entertain in the near future? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Today, a very special topic, something that has been influencing almost all of us on a daily basis, but we haven't really taken the time to break it down. And in the near past, we have seen many people misinterpreting, sometimes misunderstanding what exactly this subject entails, and that is the criminal justice process within this country. Now, it's a vast topic, and we need to talk about the nuances, the basic nitty-gritties that people have missed out on and really affect either witnesses, victims, and even the accused in most scenarios. So we need to get a breakdown from an expert in this field, a person who has had an immense amount of experience so as to give us the grassroots level of what exactly is happening. And that is a guest who has been on the show again previously as well, President's Counsel Tirantha Walaliyadda. Thank you so much, sir, for joining us once again. A lot of things to speak to you, sir, on today's topic, but as usual, we give our viewers a small breakdown so that viewers are aware of where we head with the entire discussion. Firstly, we'll be talking about the criminal investigation process and what exactly that will be including. Secondly, the authorities that are involved when it comes to this topic. Thirdly, the appeals and remand process. And finally, the reformation aspect that we need to discuss when it comes to criminal justice.
Hello, my name is Nikini Shakia and I'm a law student. My question is about crime investigation. What are the key elements of the criminal investigation process within Sri Lanka?
All right, let's get into the discussion. Thank you once again, President's Counsel Tirantha Walaliyadda, for joining us. Previous time also we had a very fruitful discussion, and something we can really draw from is your experience, and something that most of our viewers would also like to see, witnesses. Something key would be the experience that you have had within this field in criminal justice. Now, for the first segment, we want to start with the criminal investigation process. Again, in other countries, one would identify it as maybe like the crime scene investigation, but here we have it as an entire plethora of different elements. We'll break it down one by one, sir. How exactly do you enter, as in what is the introduction that you would give for the Sri Lankan crimes investigation process? What is present? What are the key areas that we need to look at?
First of all, I will tell you, not you, people, why I came in this pit. What of my people said, don't do this, right? You must go in your President's Counsel uniform. I said, no. The reason is, we have seen so many very learned President's Counsel in their full ties and everything and all that, and come and say very important things. And the general public just listening to this. I'm talking about the general public who are not lawyers or have no legal education. And they believe what they say. Next day, another President's Counsel, the same kid comes, there is something else. What are they going to believe?
Confusion.
You know, that is why I said I come, I'm not here to address a court. I'm here through your channel to send a message to the general public, you know, because you see, I belong to the general public, but the general public does not belong to me, understand? Yeah. Nor do I represent the general public. I don't represent the general public. I represent only myself and my views. Yeah. So that is why I said I am coming as an ordinary person just to give very, shall we say, a simply understood message
Yeah.
to the people who are interested in listening to this, that is the public,
Yeah.
And not, say this and that, all sorts of big sections and all that. I have only a few sections to cite here, even those need not be cited, but I will give the public a general indication of what the situation is.
Yeah.
Right? That is why I came.
Yeah.
Your question, you see, there is a certain hidden part in the Code of Criminal Procedure which governs investigations,
Right.
which very few people seem to utilize, or very few people seem to know.
Know about, yeah.
I think the public should be informed. You see, what it says is, if you look at, if I may mention a section,
Yes, please.
110 Criminal Procedure,
Yeah.
subsection 2. What it says is, when the police investigate
Yeah.
a suspect or record their statement, the suspect is bound to answer truthfully,
Yes.
right? Every question that is put to them, except those that will tend to incriminate him.
Right. And the parallel we draw is the Fifth Amendment in the US.
Precisely. That is actually the Miranda warning.
Yeah.
Miranda warning is embodied in the code, but nobody seems to be utilizing it,
Yeah.
So, the suspect who is being investigated, if he thinks that he is going to be incriminated, supposing I ask you, have you got a forged deed with you? You can say, I am not answering the question, I am pleading my rights under 110,
Right.
subsection 2. And then what happens? I have done that once,
Right.
And the investigation, you see, why do you have a police? Any suspect is entitled. Supposing somebody says, where is the credit card? Supposing the credit card is raised to an illegal account. Suspect is entitled to say, 110(2), I am not answering the question.
Right.
And remain silent. And there is nothing that the police can do about it, nothing that the court can do about it.
Right.
You know what I mean? So, you see, the police must investigate, no?
Yeah.
They can't get the suspect to investigate himself. You know what I mean?
Yeah, true.
Now, what happens here is actually it's the problem with the bail.
Right.
The Bail Act, lot of people think that if you don't give an undertaking to the court to assist the investigation, you will not get bail.
Right.
Now, can you imagine a situation where the suspect assists the investigation to get himself whacked? No. Right? Right. I mean, if he is guilty,
Yeah.
that is a matter for the police. Yeah. And the Bail Act is under section 14. It says any person who obstructs the investigation, right, may not be given bail.
Right.
But not answering a question is certainly not obstructing.
Right.
Hiding evidence is obstructing.
Okay.
But you say, I am not answering the question, you can find it yourself.
True.
And then you leave the police to do their jobs, that's what they are paid for.
True.
Otherwise, what will happen is, suspect and investigate himself, make all the incriminating statements, and then produce all the illegal documents that he has. Then he can send it to the Attorney General. And the Attorney General will tell him, you better indict yourself. So suspect can draft his own indictment, send it to the High Court, and plead guilty. What is the meaning of this? It's rubbish, no?
True.
You see? So what I am saying is that the people should know their rights.
Yeah.
This is the American system. The Fifth Amendment, Fifth and Sixth Amendments of the American Constitution, which are embodied here. The suspect is absolutely entitled to say, I am not answering that question.
Okay.
He doesn't give any reason for that. Right?
He doesn't have to give a reason.
No, he doesn't give a reason. I am not answering the question. Right? There's nothing that anybody can do. If it comes to a push, it's very incriminatory questions. You see, it is nonsense, no? And then that is why I say that at every investigation, at every interrogation of a suspect, a lawyer must necessarily be present.
Right.
But suspect doesn't know, he doesn't know his rights here. So the lawyer must be present. Don't answer the question. Don't answer the question. Don't answer the question. But without a lawyer, suspect is nowhere. And bail certainly can't be refused because he doesn't go with the police running all over the countryside, showing the knife and showing the guns and showing the illegal documents and showing the, his accounts and all those things. Bail can't be refused for that.
Yeah.
Bail can be refused only if you obstruct it, obstruct the investigation. That is threatening witnesses and, hiding evidence, that type of thing.
Yeah.
So even under the PTA.
Right. Yeah, that's an area I wanted to discuss with you. Yeah.
You want to ask a special question?
We wanted to take it
That
up
is what I have
also.
to say about the normal criminal system, criminal procedure code. The suspect should be represented by a lawyer in the event of it being interrogated. It's a necessary thing. Otherwise, it's absurd. This also goes to the presumption of innocence.
Yes.
But I must tell you one thing. This is investigation stage,
Yeah.
right? The court situation is different.
Yes,
If
we
you
will
get-
come to that. Yeah.
you get on that.
Yeah.
That is what I will say.
Yeah. So, since we are, again, when it comes to the investigation stage, multiple elements are there. And then you spoke about, I think, the most important one, which is drafting the statement, the initial statements, and then the creation of the B report based on the other elements of that specific crime. What about the admission of certain elements of evidence? Where do we need to look at what are the things that either suspect or person should be aware of when it comes to investigation and the admission of evidence? Because it's a huge area, but what are the key areas
It's
that
a very simple answer. He need not admit to anything.
Right.
That is what I said under this section. He need not admit to anything. I am not answering. That's all.
Right.
He need not, you see, at the end of the day, when he comes to a trial stage, the police don't do their job. You might find that there is no case against him, and he has to be discharged.
Yeah.
Right? I am not saying this to exonerate guilty people.
True.
Please don't misunderstand me.
Yeah.
But I am telling you are the rights of the suspect.
Yeah.
The rights. He must be entitled. He is entitled to know that. No.
Yeah.
If the police can't investigate and prove their case, that is not the suspect's fault.
Right.
I am just telling you the suspect's rights, not to exonerate him, but just see his rights. He must feel his rights.
Right. So I think you opened the window to a lot of points that I want to discuss, and I think this really pushes us well into our next segment as well. We'll take a very short break. You're watching Law, Land and Liberty. Stay with us as we discuss further with President's Counsel, Tirantha Walaliyadda.
Hello, my name is Samadhi and I'm a mechatronics graduate. So my question is about institutions and enforcement authorities. In relevance to the enforcement of criminal law, what are the key institutions that have been identified?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel, Tirantha Walaliyadda. It's a very interesting first segment, and it's always very interesting to speak to you about the various things that you have taught us specifically within this field. This segment, I think there have a lot of elements within our first segment that we have to really continue in this segment as well. But primarily, I want to talk about agency, authorities, institutions. What are the key elements? What are their mandates? What are they supposed to be doing? Now, we focused a bit on the police. And I think, as you mentioned, sir, something that we have witnessed in what you have mentioned, though you are a defense attorney, you are very critical.
On the other side also.
Yes, exactly. You are very critical of the suspects, the culprits that are in part of this. You are very critical about how they should be handled, and you believe a strengthened mechanism should be taken, a more stronger approach, specifically when it comes to issues of drugs. If I'm not mistaken. Now, the police held in one side. What about the AG's department? Now, what is the role that they will play either in part of investigation, in part of evidence gathering, in part of documentation? Is it just a role of looking at the facts and then applying whether there is a case here or not? Or is there a deeper, more nuanced role that the AG's department has to play?
The Attorney General, this is not like the District Attorney's Office of America or England, right? There is no DA's office here.
Yeah.
Right? the AG is there, and then in the various districts, in the high courts, you find the state counsel or senior state counsel, and there are supervising senior state counsel or DS, Deputy Solicitor General, who are doing that. That is the establishment. But there is no district attorney who can direct the investigations, in the sense that, you see, the problem in the Criminal Procedure Code is the Attorney General is entitled to summon any police officer to his chamber, and the police officer is bound to comply.
Right.
And in a complicated case, he can summon on his own motion, or the police can ask him for advice. But the problem is, there is nothing that says as to what happens if they don't follow the advice.
Okay.
That's a bit of, it's a silly section, no?
Right, no penalties, nothing of that sort.
The Attorney General can summon, he can advise.
Yeah.
But if the police officer doesn't follow the advice, there is nothing in the Criminal Procedure Code that says what can be done about it. So the Attorney General is really helpless in this situation. I think there should be an amendment. If the police officer does not comply, that he will be charged with some sort of offense,
Yeah.
You see, otherwise, the AG department becomes deformed because of that, because whatever instructions he gives, the police don't follow. And at the end of it, the Attorney General gets the blame. No, that is the sad part of it.
Yeah.
The sad part of it, the AG gets the blame. What is the AG doing? What can the AG do?
He's powerless in that scenario.
He is powerless in the sense that he can give he can give it in writing, he can even point a gun and this is what he must do. But the police officer is not bound to follow it.
Right.
This is a problem.
One thing I want to clarify at that point, sir, now, when it comes to a criminal case, the state will represent the prosecutorial part, which will be the AG's department, and the defense will be by the other. Will, in that scenario, the state has a very limited role, is
Yes.
how you are characterizing. They wouldn't have...
Very limited role because the Attorney General is stuck.
Yeah. The reason why I'm asking this is, now we saw in previous cases where cases were filed and there was a public push, and based on that push there were cases filed, but at the end, I think you were also mentioning charges couldn't be raised, there were issues in the entire process. So there is a public societal sort of like element to this as well, the pressure that comes. But again, I come back to the question of what is the role then of the Attorney General? If is it to listen to public policy, or is it basically to pay attention to what the facts are and then proceed?
The Attorney General is, shall we say, confined to the information provided by the police.
Okay.
The police will do the investigation, then they will send the file to the Attorney General. Attorney General look into the matter, and then if there is something missing, Attorney General record this person's evidence, record that person's evidence, arrest this person. He can do that, he can send it in writing.
Yeah.
But if they don't do it, then nothing the Attorney General can do.
Okay.
So the Attorney General, it is actually a supervisory role with no power behind it, you know what I mean?
Right.
So when something goes wrong,
Okay, advisory.
everybody blames the Attorney General.
Yeah. Yeah.
You see? And now where these other cases are concerned, where the Attorney General withdrew certain cases, that is, of course, you see, I think the public should be informed that in most of these cases where this fraud and corruption are involved, that was a technical issue.
Yeah.
Because at that time, if you look at the bribery, this Commission Act,
Yeah.
the prosecution must be mandated by the Commission. That means 3 people,
Right.
3 commissioners. Most of these cases that were withdrawn on technical ground, only 2 had signed it. So you must ask the person who drafted the act as to why he didn't do that, because in all the other cases where these special provisions are there is a particular saving clause which says the deficit in the quorum will not invalidate the act.
Okay.
The deficit if there are 3, only 2 take the decision, that the fact that 1 is missing will not invalidate the decision. Okay. But in this particular bribery act, this new one that came with the Bribery Commissions Act, that section, that clause is not there. So you must ask the person who drafted it.
So that is something that we see when it comes to other commissions, is it? Or?
Yeah, in all the other, I checked all the other commissions.
Right.
There is a saving clause which says any act done by 2 people or 3 people or 4 people which is not the complete quorum, it is not invalid, it is valid. But this particular act doesn't have it.
Okay. Just to shift our sort of optics.
And not only that, I must tell you this much. Then everybody blames the Attorney General for withdrawing the case.
Yes.
That is wrong, because there is nothing that he can do.
Because that's all they see in terms of
that is all
the media.
there is nothing that the Attorney General AG can do.
Yeah.
You know.
Yeah. So just to again shift the optics, the courts. Now the Attorney General, I think something that we have brought up within this program quite a few times is this is an adversarial system. So the lawyers, the Attorney General has a bigger role to play in terms of the entire justice, how justice, the process works. What exactly will the courts be playing, the role that they will be playing when it comes to, does the activity or the inclusion of the courts increase as we go up the scale? Or should we settle more issues either in the High Court stage when it comes to criminal cases? What is the role that the courts are playing?
The High Court will decide on the facts.
Okay.
No, it will decide not whether the accused person must have committed the crime. They must decide as to whether he in fact committed the crime.
Okay.
Get my meaning? Yeah. If they think, well, this chap must have done it, that is not a reason to convict.
Right.
The court must find he is the man, he did it, and he must come to that conclusion. That is based on the facts of the case. Right? When he goes to the Court of Appeal, the Court of Appeal will consider whether the High Court trial was held legally, whether illegal orders were made, whether the law was transgressed, you know, and that type of situation. And the Court of Appeal is not a trial court. It's not a trial court as to whether so and so told the truth, so and so did not tell the truth. It's not the business of the Court of Appeal. There is a propriety of the proceedings. And then if there is a big mistake, then the Court of Appeal will either acquit the accused or say you would have a retrial. But of course there is a saving clause which is being used, I think, very shall we say, liberally by the Court of Appeal these days, because the prosecutions are so, shall we say, you know, whatever, right? And they say, well, whatever defects there have been in the legality of the trial, if it has not prejudiced the accused, the conviction will be upheld.
Okay.
You know, that I think is an extremely dangerous provision, you know. Right. Whatever illegalities have been there, if the evidence is sufficient to convict the accused, and if the illegality are not prejudiced the accused, conviction is upheld. Most of the cases go by that provision, you know. That I think is a very dangerous situation.
Right. Pretty charitable interpretation.
No, I'm not talking on behalf of because now what happens is the state, the Crown or the Legislative Department depends on the proviso to get rid of all the illegalities in the prosecution, which they prosecuted. You know what I mean? They prosecute, they make the mistake, and they plead their own illegality and say, well, don't worry, the rest of it is, he has not been prejudiced. So now I think that may not be quite, maybe they should take another view at the matter, no?
Right. No, that's true, sir. I want to ask you about strengthening these institutions. If we can, just before we go to a break, sir, just talk a bit about now. Without getting into details, I think most recently we saw the issue of the rehabilitation center, the Kandagadu Rehabilitation Center. Now, like that, we have multiple institutions that have play an important role in terms of either the prisons and all of that. Where, without talking about reforms per se, are there requirements to strengthen these institutions as of now when talking about authorities?
You're asking a dangerous question, my friend. I'm from a dangerous man.
We'll try and answer it in a subtle way.
I think there is nothing subtle in what I say, no.
True.
Right? The Rehabilitation Act should be abolished. You know, should be abolished, because this is a big nuisance in this whole country. And you find what happened at Kandagadu, these are supposed to be drug addicts.
True.
Right? And they are trying to reform drug addicts. You check with the medical people, they say, how can you reform these heroin addicts or addicts who are, you know, with dangerous drugs? How can they get out? And they come to the nearest place, take another shot, you know, and they are back in business, you know what I mean? So, and now what happened in Kandagadu, They beat each other, they almost murdered each other, hit the police also, right? And they ran out of the place. Now there are 40 odd people missing, right? Now you see, now this is why I feel sorry for the police, you know. Now they are chase behind these fellows now again, no? Find them, and then while they are arresting, they might even get shot, no? The police officers might even get shot, the way things are now. I don't see why that has to happen. You see, you must abolish these rehabilitation centers. Send the people, send these drug addicts to 10 years rigorous imprisonment, that's all. No treatment. I mean, why should we? I mean, you and I are the people who are paying for their upkeep, no? If they don't want to be, if they don't want this, right? Why should we waste our time with these people? Right. They should be put into jail. If they are reforming, let them reform themselves in jail, in hard labor. And I would say most of them might reform, right? But this type of, you know, mollycoddling and, singing their lullabies and tell them to go to sleep. Why should we do that? Because the police have risked their life to catch these fellows, no?
True.
I think that rehabilitation thing should be absolutely abolished.
A very strong stance on that point.
I've been, and where traffickers are concerned, you can never rehabilitate a trafficker, no? He does it for money. How can you rehabilitate a money spinner? You can't rehabilitate him, no?
He might not even be a user.
Exactly. So where the traffickers are concerned, I have always maintained for the past 10 years, if a trafficker is convicted and his appeal is dismissed, hang him.
To use the capital punishment.
Capital punishment, the president must have the guts and the backbone to sign the warrant for his execution and get it done without just playing the fool here, you know what I mean? But from 1971, nothing has happened, no? That is why this country has gone to this situation, no? That is why traffickers are running through the school grounds, you know, transporting drugs through the school grounds in their three-wheeler without any fear, no? You hang them, that will not happen. I mean, I appear for a different matter. But that's my job, no?
True.
But if the situation is the convicted and Supreme Court dismisses, the president must have the guts to sign the death warrant. What is the problem here?
Exactly. Very, very interesting segment there. We'll take a very short break. You are with us on Law, Land and Liberty. Stay with us as we continue the discussion on the criminal justice process here with President's Counsel Tirantha.
Hello, my name is and I am a mechanical engineering graduate. And my question is about remand and appeal. As in, how does the remand process differ in relevance to different crimes, and how can these decisions be appealed?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Tirantha Walaliyadda. In our third segment, we want to focus a bit on the appeals process and the remand process, which is two of the key aspects that we see when it comes to the public forum, basically, where we discuss a person under remand custody that has a certain investigative process that happens, person who's given bail, and then a crime is recommitted in those scenarios. And I think a lot of clarity is required in these scenarios. So where would you start? I think from the Bail Act, we spoke about it in the first segment. You mentioned about Section 14, if I'm not mistaken, about the key areas that comes there. Where do we need to really focus on when it comes to giving bail? What are the key factors that the court considers? If you can start from there, we can continue the discussion.
I want to add a little bit to the previous one. Right? You see, now when it comes to death sentence, a lot of these human rights activists say, human rights, how can you do this? We must remember the human rights of the children in this country, you know, right? They also must be looked after. They also have rights. The children's rights, the human rights, they also have rights.
The victims.
The victims. And if they get into drugs, they will live for about 20, 30 years, but they will be crippled for life.
Yeah.
And they ruin the entire society. So when you talk about human rights, think of the other side of the story also as well.
Yeah.
That is what I'm saying. You must hang these fellows,
Yeah, I think a similar opinion was held by Lee Kuan Yew, and I think Dr. Mahathir Mohamad also about to consider how bad the traffickers affect society and something that needs to be considered.
Ruining the society,
Yeah.
Ruining.
Yeah.
What is the question?
Yeah, my question was going to be on bail. So if you can, the first clarification, if you could provide to us, what is considered when giving bail in a criminal offence, and we can continue the discussion.
What it says is that the Bail Act.
Yeah.
In the good old days, there was something called the bailable and non-bailable offences.
Yeah.
Right? That are superseded by the Bail Act.
Okay.
In bailable offences, the accused was entitled to bail.
Right.
There are little minor offences. If he produced, he is entitled to bail. In the non-bailable offences, it was given to the discretion of the non-bailable. Doesn't mean that you can't give bail, but the discretion is given to the judge to give bail or not give bail.
Okay.
Right. So that's bailable and non-bailable. It was superseded by this Bail Act, which I really don't consider very very good thing. So now you see, even if you spit on the street, you may refuse bail. The dangerous section in the Bail Act is that if it causes public what do you call that?
Is it obstructing the course of justice?
No.
Public unrest.
Public unrest. If it causes public unrest, you are not given bail. That is not a good idea, no? Right? So because now supposing a three-wheeler, right, is smashed up, right? Then all the three-wheeler line up in front of the courthouse, and the police file a Tanzania report saying public unrest, right? And this man is not given bail, and he may not have done it even. Even the trial has not. He has not even been charged with the offence.
Right.
So what is the fairness in that? He has not even been charged at investigative stage, just because these people are saying public unrest.
Yeah.
He is not being given bail. I think that is the absolutely ridiculous situation, no? The easiest for the police is just to say, if that is the case, then the police must file affidavits.
Yeah.
File them, put it on affidavit, which they will never do. They just put on the B report, public unrest will be caused, therefore no bail. And you have somebody lining up in front of the courthouse. This is famous registration, lining up before courthouses. It's a hobby, Anything happens, he will spit on the street, people line up before the courthouse,
Public pressure.
So that is a hobby now.
Yeah.
So that type of, I think that these sections are ridiculous.
Right. So, but just to push back on what you're saying.
And not only that, now when it comes, like I told you earlier, obstructing, now see the situation, there's another section which says, if he will commit further offences, that Bail Act says, if there's a possibility that he will commit further offences.
Yeah, that was going to be my question.
Right, and he will not be granted bail.
Yeah.
Now to commit a further offence, he must be proved that he committed this offence, no?
Right.
To think about committing further offences, it must be proved that he committed this offence. That is not being proved.
But
he is still on investigation.
But don't you think there are cases where, given the risk to society, that should be implemented?
No. How? Because it is against the fundamentals of the law, no? The fundamentals, the presumption of innocence, the fundamentals of the right to silence. It goes against the entire vein of the legal system here, no?
Right.
If you say, well, he might commit further offences. Yeah. So you are presuming that he has committed this offence, no? Yeah. The court presumes that he has committed this offence. There is not investigation, not even he has just been arrested.
Right.
You know what I mean?
Yeah.
So I think that is absolutely unfair thing. This Bail Act should, these are ridiculous acts,
So the comparison is to other countries. They would consider things like flight risk, which is what's considered in US, and that's how they decide whether the bail should be awarded or not. You believe something like that should be included here, or what should be the criteria? Basically, I'm asking when bail
is whether the man is entitled to bail depends on his personal circumstances. What is the allegation, right? And then, like there was some judge who said, I think Kandraja Justice, that each case is decided on the facts of each case, on the merits of each case.
Yeah.
So there is no rule that you can say this is why you should give bail, this way you should not give bail.
Exactly, yeah.
So there is no specific rule here. But the judge must be alive to what is happening. He must be alive to what the situation, you know. If he is alive to the situation, he can legitimately refuse bail.
Right.
But not under these bail-like situations.
Okay.
You know?
Okay. So just to talk a bit about the remand issue now, this I think goes hand in hand with, we've been discussing the PTA multiple times within this program. It's a contentious topic, and the society is split on, you know, how they have understood it. What are your takes on that, about how the PTA is enforced, what is the law, and then if you can explain to us how a person is taken in remand, either arrested, where are the changes that are required in that entire process?
See, it all depends on what terrorism is, right? And in these various forums that discuss this matter, they give all sorts of ideas about terrorism, no, right? Now, if anybody tries to overthrow the government,
Yes.
or assassinate people who are listed as in the PTA, right?
Yeah.
That is called terrorism, or an attempt to do that, or conspiracy to do that.
Yeah.
Right? So that it depends on the situation there.
Yeah.
And in an emergency type of situation, to quell a riot,
Yes.
right? To quell a riot, you don't have to ignore the PTA. The emergency is there for that, right? To quell a riot. But in this situation, put it this way, if there are reports that foreign elements are involved in overthrowing this government or causing disturbance to this government, or having a forceful rejection of the government, and there is evidence to that effect, or they are investigating that matter, then I think the Prevention of Terrorism Act must come into operation.
Right. I think very concisely that gives a very good understanding of where the PTA should be applicable. Just before we go in for a
But I must say one thing.
Yeah.
The PTA applicable or not, legal facilities should be given to the corpus or the suspect. That is essential.
It's in representation and things
It
like
must be represented
Yeah.
at every point.
Yeah. So just to touch on, I think this won't be too long, about the appeals process. When it comes to a criminal offense, if you can give us an explanation, what a person is a person, just to, I think, a clarification for the layman. When a person appeals after the person is convicted, is there a presumption of innocence? How is that
No.
person included? Right.
You see, that is a very important matter. When the person, after he is convicted, he appeals as a convict.
Right.
He says, he pleads with the court to say, please
Quell the decision.
please vacate this conviction.
Yeah. Yeah.
Please vacate this conviction, make me and acquit me.
Yeah.
So he puts the appeal as as a convict.
Right.
There is no presumption. The presumption of innocence starts in the High Court when he gets into the dock. When he gets into the dock, the presumption of innocence starts. It ends the moment the High Court convicts him.
Right.
It ends. Then he is a convict. When he appeals as a convict. So the presumption of innocence does not apply there.
Yeah, yeah. Very concisely puts, I think, a lot of clarity given in all of the three segments. We'll take a very short break and we'll come back and we'll continue this discussion with President's Counsel, Tirantha. Stay with us.
Hello, my name is Walaliyadda. I'm an electronic engineering undergraduate. My question is about criminal law reforms. What are the key areas of reforms that are of immediate requirement in relevance to criminal law?
Welcome back to Law, Land and Liberty. This is our last segment. We are in conversation with President's Counsel, Tirantha Walaliyadda. So this segment we wanted to give in a majority to the reform aspect that is required. You know, the legislature is in charge of this entire role. and people have been critical over time. I think we don't have to get into the nuances there, but I think in every segment you consistently showed us these are things that needs to change in order for the smoother running, in order for justice to be executed properly. What are the key areas that you believe we need to focus on as of right now? I think somewhere we stopped was on the AG's role in all of this, the powers and the authority that is given to the Attorney General. Where else do you think some immediate sort of reformation is required?
One thing is, I didn't go to the 21st Amendment is coming now.
Yeah.
Right? There must be a provision where the Attorney General, because you see, the Attorney General is the chief law officer of the country.
Yeah.
Right? He is the chief law officer. So he must have authority to prosecute, to investigate, no?
Yeah. Yeah.
And if necessary, discharge the accused and do whatever you want, you know. The police, there must be a section introduced in the Criminal Procedure Code, like I told you.
Yeah.
If the police do not follow the Attorney General's advice, they will be subject to strict liability.
Okay.
Maybe even a jail term. You see, now what happens is, if there is any problem, he is transferred. You know, he is transferred to Kushi station, you know. From Colombo, he is sent to Norelli, where he can have a nice vacation, police officer. When everything blows down, he comes back home peacefully, you know. That is rubbish, no? So, now even in the Kandakadu incident, I think, some people are remanded, no?
Yeah.
Right? But the people who jumped all over the place and escaped, they are still searching for him. Now, how is the police department going to work? You tell me this, how is the police department going to work if at any moment they surround the police station, right? And start hooting and caterwauling and saying, you know, our human rights have been destroyed, to find that they have arrested a drug addict, right? Or they may have shot the fellow or whatever, that's a different matter.
Yeah.
But how are they going to work if this type of thing is tolerated? Now it is the name of the game is that, no, if anything happens, the police station is surrounded, right? And what happens, the OIC is dismissed or suspended.
Right.
How are the police going to operate?
True.
I mean, it is ridiculous, no?
Yeah.
So that type of thing has to be stopped, you know. And this, if there is an allegation of police assault, right? So we see on TV, you know what happens? The police are, you know, almost being murdered, no? Right? Or 100 people gathering around the police station. And this tiny little police force trying to defend themselves. I think there should be some serious consideration given to the police officers, you know, not just to the general public, who are to find that the person who has been arrested or injured, he is a drug trafficker or a rapist or something or the other, you know.
Yeah.
So how, and the moment it happens, our 225 in the famous Derana will start shouting human rights, human rights, human rights, human rights, and the police officers are suspended or transferred.
Yeah.
That is rubbish, no?
Yeah.
So I think the executive should make a far more firm stand on this and assist and give the police a concrete footing to stand on and say, you do your job. But the moment anything happens, they're dismissed. Do you think it's fair?
Right, that's true.
And not only that, you must remember that the police, they risk their lives to catch these chaps, no?
Yeah.
How many have been shot? How many have died?
True.
So they also must be given their, police also must be given their due, no? And due respect for what they are doing.
Exactly.
You know?
So a lot of things that we have gathered from today's program, and a lot of things I want to ask you as well, but unfortunately time has come against us and we'll have to end here. I hope we can meet again on this program and we can discuss another topic. Thank you so much for joining us, President's Counsel, Tirantha, Walaliyadda. A lot of important things that we discussed today, sir. Thank you. All right. The pursuit of justice begins by the presence of a strong legal framework to govern the basic crimes and protect the innocent. But that behavioral change needs to arise from the people. Former Minister of Law and Justice in India, B.R. Ambedkar once said, "A just society is that society in which ascending sense of reverence and descending sense of contempt is dissolved into the creation of a compassionate society." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/otherthanenglish. I'm Dardir Tanwasam. Have a great night.